But in Ohio, where fracking has been going on for many years, 92% of the streams are too contaminated to enter. They're dangerous. So let me get out of this. How do I get out of this? Escape. Okay, next we have David Dorfman. He's a professor with PACE, and as well as the supervising attorney of the Criminal Justice Clinic. And I'll let him take it from there.
Okay. How you doing? So I'm from downstate, actually. I run the Criminal Defense Clinic at Pace Law School, which is now called the Elizabeth Howe School of Law at Pace University. I've also been, and I'm a criminal defense lawyer by training. I am not an environmental lawyer. I was a public defender at the Legal Aid Society of New York in Brooklyn for 7 years. I run this clinic. The one thing that brought me into your world is the fact that I have for quite a number of years as a sideline represented protesters. I got very active during Occupy Wall Street, and I represented people during some of those demonstrations. And then, and I'm also affiliated with the National Lawyers Guild, which is a, somewhat radical lawyers organization. They enlisted me to represent a group of protesters in Verplanck, New York. Verplanck, New York is right by Indian Point nuclear power plant. And this group of protesters, I think, and you call them pipe sitters? No. Yeah, the pipe crawlers is the way I would call it. But anyway, so you had 7 folks who, and I'll admit it now because the trial is over, they hopped the fence at 5 in the morning and they went onto a site of Spectra Energy, which was a Texas-based company that was laying a high-capacity pipeline of frack gas, ultimately coming from the Marcellus Shale region. The segment called the AIM pipeline, which is the Algonquin incremental market pipeline, it was a classic case of segmentation. That was a 30-mile segment of pipe, but in fact, if you look at the entire pipeline, starting in Pennsylvania, coming through New Jersey, through New York, under the Hudson River, hence water law, junctioning by Indian Point Power Plant, and then bringing that gas up to New England. Originally in the FERC application, it was supposed to be gas for use in New England, but it turns out all of the gas, and it is moving, is going up to Canada to be converted into liquefied natural gas and being put on boats and sent overseas. It's all for money, right? It wasn't even for the purported use of solving, some sort of gas shortage in New England. All nonsense. Anyway, so my clients at 5 in the morning jump over a fence, get onto this staging area where they're assembling the pipeline, and each pipeline segment is about 100 feet long. When I say high-capacity pipeline, we're talking about a pipe that's 48 inches in diameter. And that's enormous. That's why my clients could actually sit in there with sleeping bags and, adult diapers and foodstuffs and all that, and actually be somewhat comfortable. So anyway, I don't think I would do it at my age, but all power to them. So of the 7 people, 4 of them actually coiled in the pipe, and they were outfitted in a way where they would be there for the duration. They were literally trying to stop the pipeline from being assembled. And for about 18 hours it worked. For 18 hours, the Spectra people were unable to do their work, and the state police had to be called in, and ultimately my clients were given a deal. If you come out, right, and you don't struggle, you come out voluntarily before the next day, and we don't have to go in there and get you. We won't charge you with resisting arrest, and we won't charge you with assault if any of the police officers get injured. Instead, you'll be charged with trespass, and you'll be given what's called a desk appearance ticket, a DAT. It's like a summons, so they wouldn't have to spend the night in jail. And I had already been enlisted as their lawyer. I couldn't be on the scene because I don't want to be a witness, right? And basically, I am, as my grandmother would say, handling. I was negotiating with the state police about how we were going to deal with this, and my clients wanted to come out around the 11 o'clock news hour so they could do a presser, right, after they came out, and it all worked out fine. Good. By the way, I subsequently represented a number of other groups who did similar sorts of things, in total of, I think, 26 defendants, criminal defendants being charged with trespass or some other variation. So this particular, by the way, this was on October 10th, 2016, which is Indigenous Persons Day. And in addition to the significance of that day, it was also at the same time as what was going on in North Dakota at the Standing Rock. And in fact, my clients video recorded and projected out on social media statements while they were still in the pipeline, basically in solidarity with the folks out at Standing Rock. Actually, a number of my clients had been at Standing Rock at various times as well. So they get charged with the crimes, and then a long slog through the court system occurs. Approximately a little less than 2 years later, we finally get to trial. They are not taking a plea because we have a defense in New York State. It's actually a defense you have in pretty much every state in the union, and it's also an ancient common law defense called necessity. Okay, so hence my topic is climate necessity. We actually had 3 theories of necessity. Just to give you a quick synopsis of what necessity is, it is, basically you're allowed to break the law in order to avoid a greater harm. You're walking down the street, a house is on fire, there's a little child on the 2nd floor. Guess what? In order to save the child, you can jump a fence, you can trespass on somebody's property, you can even break down the door in order to retrieve the child. You can break the law in order to avoid a greater harm. And it's a standard common law defense, goes back to Magna Carta probably, right? But it's also a statutory defense in New York. So my clients, and I'll just read to you basically what the case law, which interprets the statutory language, says. These are the elements of the defense. The actor has acted to avoid a grave harm not of his own making, that there are not adequate legal means to avoid the harm sought to be avoided is greater than that harm that is committed by the offense itself, right? So the trespass, what's the harm committed by your trespass? It's stopping the Spectra company for 18 hours and doing what they were doing. 4, the harm must be imminent. And by the way, this is really important in all the discussions I've been hearing so far, right? There is hidden issues of imminence, right? Especially when we talk about climate necessity, and Bob Howarth, who is one of my experts, and he's right here now, he's a professor, Atkinson Distinguished Professor of Human Ecology here at Cornell, was my climate scientist expert. And we needed, and I at some point I wouldn't mind if he would tell us a little bit how he did it, but we needed to be able to make a credible argument that climate change is creating an imminent harm, not like what the NEA says, 10 years, 11 years from now it's going to be a catastrophe. That really serious harm is happening right now, and that's what we mean by imminent. And then lastly, that the action taken by my clients must be reasonably expected to avert the impending danger. So we had to really make a case. Now, there have been attempts to litigate the necessity defense in cases like that elsewhere in the country and even in New York State. I believe 2 of witnesses we have here have testified in the Wayawanda case, right, involving CPV, where necessity was raised as a defense. It was a truncated presentation. I don't think the judge really wanted to hear too much of it, but it was done. Mike Sussman was the lawyer, did a really good job. Those folks were convicted, and that was if you remember the James Cromwell, you get a Hollywood guy who is unwilling to pay a fine and he does a couple of days in jail. And that's all that was written about in the newspapers. Very little about the actual climate necessity arguments and the necessity arguments. There's a case that people may have been aware about in Minnesota, the Klapstein case, where the case went up on appeal before trial in determining whether or not the trial would be, whether the trial court could allow for a necessity defense. The intermediate appellate court said yes. The Minnesota Supreme Court just let it lie. They didn't change that. The case was then sent back for trial, but then when the trial happened, that was also what they call a valve turner case that had to do with, right, the activists going and actually turning off the pipeline. Ultimately, the judge ruled in favor of the defendants in that case, but not on climate necessity or anything, but on the failure of the prosecution to prove vandalism, prove that turning the valve in some way was an act of criminal mischief against the pipeline. And since they failed to do that, the case fell apart on that basis, and they never got to put experts on. They never got to, litigate the science of necessity and the necessity of necessity. There's been a number of cases where this has been attempted. What was great about our case, and we were very lucky, it was not anything I did, we had a judge who actually allowed us to try the whole damn case, right? And that's why the thing that's probably most historical about this case is that it is the fullest litigation of necessity defense in an environmental protest case, probably in the United States. She allowed us to put on all our experts. We had testimony for four full days. We were able to get all of our exhibits in. There is, right, this is, by the way, Ann, I think you're in this picture, right?
I am.
Right. So this is myself, obviously, wearing my monkey suit. And then not all of my clients are here, but most of them are here, plus a lot of community supporters, some of whom you may recognize. There's another wonderful picture that Bob's in that I should have put up also. Okay. Right. So how are we doing? How much more time do I got?
Yeah, well, I'd say about 8 minutes.
8 minutes, because I do want Bob to talk a little bit. So there's a lot of dimensions to this. First of all, we had 3 different necessity theories, only one of which was climate necessity, but that's what I want to talk about. So the other, just very quickly, the other one was necessity as relates to exploding pipelines, particularly within 100 feet of Indian Point nuclear power plant. And that was a big one. We had a lot of great exhibits. We had pictures of exploding pipelines. We had fires. We had maps of where the radiation would plume out to and basically create an uninhabitable eastern seaboard. Thank you very much. That's, that's pretty serious. And then the other one that was a public health one having to do with communities that lived around the pipeline, and specifically, and actually I'm going to show very quickly a little bit of a video that Bob actually laid the foundation for, which was basically an infrared video of the belching of methane from compressor stations that are located about every 20 miles along these pipelines.
Is that the first one?
Yeah, the first one's okay. It does either
It's
one.
not open. Oh, yeah. Oh,
Okay.
shoot.
No?
Oh, no, it's
not.
okay.
Will you be able to do it?
Yeah, I'm going to just okay it.
Yeah, see. See if we can show it.
Yeah, there we go.
Right. Yeah, so this is gas imaging. Obviously, methane is not visible to the human eye, but under the use of this kind of photography, you can see just what is routinely being belched out into the atmosphere by these compressor stations. Remembering that gas, as it moves down these pipelines, it's not a passive process. They need to be compressed and put, right? So this is, now, yeah, that's it. That's standard. That's 24/7. That's what's just happening. That's how the compressor station works. It burns the methane in order to push the methane, right? I don't want to take up too much time. It's a 2 or 3 minute thing. But these kinds of images, and this is me as a trial lawyer, that's my training. I needed to convince the judge, who was the trier of fact, of the imminence of the danger, the seriousness of the danger, the gravity of the danger. I knew she's a young woman. She's got 2 young children. She lives herself within about 6 miles of a compressor station. we were able to bring in evidence that there's a compressor station in Stony Point, New York, which is literally right across the Hudson River from where my clients were arrested. There's another one up in northeast in Putnam County, not that far away also. This is what's happening, and we had public health expert talking about what happens when people live near compressor stations where methane is being belched in the atmosphere on a regular basis, and actually increases when they do blowouts, when they're actually trying to clear out material from the pipeline. They actually push it out into the atmosphere at an even greater rate. And she had studies. Again, the judge allowed all of this in. And the judge, when Bob was testifying and when Larissa Durska, our physician, was testifying, she was pie-eyed, right? She was just totally absorbed in their testimony, okay? Let me just get Bob to weigh in here. We had a problem, I thought, in proving imminence. All I did is, and Bob's a really smart guy, so I just said, Bob, we have this data from DARA International, right, which is an international not-for-profit that does these studies and has been adopted by the World Health Organization and by the UN General Assembly as being a very credible source. And they say, as of, I think it was 2013 or 14, that global climate change kills 400,000 people a year. All right, I didn't want to go to property damage. I didn't want to go to illness. I want to go to death, right? I'm a trial lawyer. Death, right? So 400,000 deaths a year caused by global climate change. I needed Bob to testify as to what this 30-mile segment of pipeline kills a year. Right, so Bob, take it away. It is.
Yeah, the real challenge was trying to make it imminent, because as a climate scientist, you tend to talk about how things are getting worse, but they're going to get a hell of a lot worse yet. In 20 or 30 years, we might have 500 million people die, but that's not imminent, says Professor Dorfman.
Says the law.
So I needed to scale it down, and I enlisted help from my colleague Tony Ingracia in calculating.
Who should have also been testifying for me, but he was on vacation. We talked.
And basically, you know, I looked through the reports that Professor Dorfman pointed me towards, and looked at other reports, and they're credible. There are people dying today from climate change, and then we just scaled it to how much of that warming is due to methane, how much of that methane is coming from shale gas in the United States. It's a pretty linear calculation. The shale gas development in the United States is limited by its ability to get to market. If you make it easier to get to market, they'll increase production. I explicitly made that assumption, which is a good assumption, and the prosecutor challenged me on that, but it's good, I think. With that assumption, then you go, well, with this pipeline, it has the capacity to move this much more gas, it results in that much more production, that much more methane, and it would result imminently in, I forget the exact number.
It was 265 deaths a year. So it's 500, in the 2 years the pipeline's been in existence at the time of your testimony, it would be well over 500 deaths.
Yeah.
Right.
And you know, I actually felt quite comfortable in saying that that's a fairly strong science thing to be able to say. The logic behind it is straightforward. Although you'd have to, you know, I spent days running through those numbers to make sure they were right. And I wouldn't have ever done the calculation if I hadn't been pressed to try and deal with the immediacy, because the future of climate change is so much more scary. But we couldn't go there. And I must say it was a fascinating experience. Tony and I were also expert witnesses in the way we done the trial. That one was much more informal. We were allowed to just kind of talk. I felt like I was lecturing in a classroom. I felt very much at home. This trial, I felt like I was watching myself in Law and Order. I was asked to leave 2 or 3 times where you guys argued about some matter of law for 45 minutes at a time, where I had to sit in the hallway and not talk to anyone. I was ordered to be silent. People would come by and go, "What are you doing here?" So but mostly it was satisfying to be able to support the activists who are trying to bring this issue to attention. And to the extent I helped with that, I was grateful for the opportunity.
And you were amazing, and I want to just thank you. So I'm done. So let me just cut to the chase. So what was the verdict? Okay, so it was a mixed blessing. Okay, so first of all, of my 7 people originally, one of them is actually still has jumped bail, and I love the guy, but he left, so he never got tried. Okay, so we're down to 6. The 3 people who were accused of jumping the fence but not going into the pipeline itself, I got their cases dismissed after the prosecutor's case. I was able to show that the prosecutor was unable to make out a basic element of trespass as a matter of law. So I tried it like a street crime case. I was just basically holding the prosecution to its burden, and they couldn't prove that my client, they couldn't prove how my clients entered the location. And trespass requires breaking and entering. They couldn't prove the breaking and entering, or remaining unlawfully therein. So I was able to show for those 3 people that there were access points that were totally lawful, and they couldn't prove that my clients hadn't gone in that way. And there were no signs inside saying that being in here is trespassing. And so I got those cases dismissed. It was just classic, street trial lawyering from Brooklyn. Okay, fine. But then you got these 3 people in the pipeline, and I couldn't really credibly say that they were not remaining unlawfully therein, since the police were looking at the pipeline and telling them to get the hell out, and so that we couldn't do it that way. So after what was essentially a 2-week trial, those clients were convicted of a non-criminal trespass, not a criminal offense. It's the equivalent, like, basically of a speeding ticket, right? So then the DA, and this is, I think, is a major victory, though it has no precedential value. But the DA asked for 300 hours of community service per person, plus the maximum fine. And the judge says, I'm not sentencing them to anything. They're getting unconditional discharges, meaning no conditions whatsoever on their being discharged from court, not even having to pay, not only not having to pay a fine, not even having to pay mandatory surcharges and court costs. And then she said, it's on the record, I don't want to deter their activism, which I thought was great. I'm still, by the way, appealing the conviction, because I see from some of her reasoning in her decision, I see an opening for making some inroads on the necessity defense for future protesters. Because, and this is it, and I apologize for going over a little bit, but pardon me for getting into the weeds. She basically agreed that we had met our burden on that it was a grave harm, not of their own making, that it was, that the harm sought to be avoided is greater than that was committed. She even agreed that what they did was reasonably calculated to stop the pipeline. Because what we were able to show was, just around the time they were in that pipeline was the time when the Standing Rock people had convinced the Obama administration to approach energy partners and to go into hiatus on that pipeline. And that was in part due to civil disobedience. So what my clients were doing very expressly was mimicking what was happening out in North Dakota, and it could be reasonably calculated to avert the harm. And there was a couple of other, there was also a possibility of a water permit being pulled by DEC, because just around that time, Spectra had lost a drill bit underneath the Hudson River and had to re-drill, right? And so there was concern there. So it was reasonably calculated to avert the harm. The main problem, and the reason my clients got convicted, was that she argued that we had not established that there weren't adequate legal means to avoid the harm. And what the judge said was, why weren't they interveners at FERC? Because some of the testimony had come out that FERC, in spite of the fact that it is, as was said earlier today, a rubber stamp for the power industry, nevertheless, there is something called intervener status, and that none of my 3 pipe crawlers had been interveners at that time. But she also was told that being an intervener doesn't give you any real status other than getting information earlier. You don't actually have the ability to sit at the table and to help craft policy. It's not like you're truly in the deliberative process of FERC, and she knew that. So that's an error, and I think there's enough of a record to show that if she's hinging her entire ruling on that issue, I think we have a decent appeals issue. So I filed my notice of appeal. I'm actually writing the appeal right now, because I do never say die, right? And I'm hoping that we're able to actually get an ultimate victory in this case, by not just the partial victory that I think we have received. So that's the story of, there's a lot more, but that's the story of the pipeline crawler.
You know, we got the round table at the end.
I'm sorry?
I
can hear you.
You can add to it at the round table at the end.
I'm sorry?
We have a little discussion at the end. So
Oh, yeah, I'll be there for the discussion.
We gotta get back.
Actually, there's one last thing very important. Because this is a shameless boost for my law school where I teach. I've been teaching there for 24 years. So I'm a criminal defense person and I have a criminal justice clinic, but the students I used to help me in this case were all from the environmental clinic. So, and our environmental clinic is the lawyer for Hudson River Keeper, if you didn't know that. They don't have that many cases, so it looks like I may end up getting affiliated more permanently with our environmental clinic and doing more of these cases using the law school and the law students for assistance. So, you know, this is not a one-off. We'll be doing more of these kinds of cases in the future. So, thanks.